Thank you, Your Honor. We're here in the state of Ohio versus Trayvon Hopkins, case numbers 26CR291, 26CR869, and 24CR1155. The defendant is present with counsel Carly Snavely. We were last here on July 2nd, 2026. We're in case 26CR291. The defendant pled guilty to a lesser included offense of count 1, unlawful sexual conduct with a minor, a felony of the 4th degree. Count 2, corrupting another with drugs, a felony of the 4th degree. And count 3, a lesser included offense being unlawful sexual conduct with a minor, a felony of the 4th degree. And in case 26CR869, the defendant pled guilty to counts 1, 2, and 3, unlawful sexual conduct with a minor, felonies of the 3rd degree, and corrupting another with drugs, a felony of the 4th degree. We are here today for sentencing on those cases, as well as sentencing in case 24CR1155, where the defendant was previously on an intervention plan, which has since been terminated.
Those are 6 F5s?
Yes, Your Honor. Receiving stolen property and identity fraud counts.
All right, Ms. Snavely?
Yes, Your Honor. The state's recitation is accurate. I've had the opportunity to review the PSR and the site eval, and we are prepared to proceed with sentencing. I suppose I want to start by stating that anything I state here today on behalf of my client is not offered as an excuse to his actions. Certainly there is absolutely nothing I could or would say that would excuse the conduct that has brought him before this court. That being said, I believe he has accepted responsibility for it. He did enter pleas pursuant to a bill of information and, is prepared to accept any consequences that the court deems appropriate. In reviewing the psych evaluation that was ordered by this court, Mr. Hopkins indicates, I need help with this because I'm addicted to sex and want help to stop. I've had a lot of problems with how I think and what I remember ever since I was shot in the head 2 years ago. I'm scared of being in jail because I don't want other inmates to find out why I'm there and try to kill me. I just want to get better with how I think and stop using all the stuff I do. He goes on to state that he needs treatment and does not feel that incarceration would be what is in his best interest, and is asking the court to impose a community control sanction. While those statements may come off as self-serving, I believe it is honest and certainly sincere. I also believe that there is some evidence in support of it. Specifically, after reviewing the PSR and particularly Mr. Hopkins' discipline history while incarcerated, it does not appear that the many conditions from which he suffers from and has been previously diagnosed, they seem to be getting progressively worse and not better. It doesn't seem like things are improving nonetheless. Though I'm certainly far from qualified to diagnose him or make recommendations in terms of what sort of level of care he requires, or to determine the root of the issue that is driving these behaviors that have caused him to come before the court. I do believe that the trauma that he disclosed just as of late does likely explain a lot of this behavior, in conjunction with his mental health conditions and his substance use. I think that there's probably a pretty good chance that what he experienced back when he was 16 and what he reports has continued for the 9 years that have followed is likely what may be driving this. I thought that the recommendations set forth in the psych evaluation did a very good job of addressing all of the issues that he suffers from. Certainly his trauma, the mental health issues, or his dual diagnosis. Unfortunately, it's my understanding that he is not eligible for NeoCap, which was disappointing because I had planned to ask the court to follow the recommendations set forth in the psych evaluation or following the psych evaluation, but it has been very difficult to find any sort of a long-term residential facility that will accept Mr. Hopkins as a result of the sex offense convictions. Nonetheless, I do believe that, if I would ask the court to consider a community control sanction and some sort of combination of, some combination of treatment, I can't help but feel that compliance with extensive and intensive treatment, would put him in the best position to change his ways and to avoid these future behaviors and for history to repeat itself. I don't envy the position that this court has faced. It's certainly difficult. I think he was also, it's clear that from the PSR that he was likely under the influence in a lot of these or in all of the matters. It sounds like he was using substances on a regular basis. I don't think there's any question that he needs intensive treatment for his mental health conditions and his substance abuse. I know that I have previously I represented Mr. Hopkins in the case in which this court gave him the opportunity to participate in the ILC program, and at that point in time he was unwilling to acknowledge that there was any sort of a substance issue, despite the fact that he was using marijuana on a regular basis. He always until now really always insisted that there's that it was medicinal and that it helped with his anxiety and that it wasn't a problem. And so I have seen a change in him in that regard. He's the one thing that was certainly consistent throughout the entirety of the reports that I read was his acknowledgement of the issues that he faces and his what I believe is his sincere desire to get help. He is not in denial about the fact that his actions are deviant and criminal, and I don't think he knows or has any way to really control them or the coping skills to really prevent them in the future. And naturally my fear is that should this court impose a prison sentence, he is eventually going to get out of prison. And if he doesn't receive the necessary treatment that he needs in the institution, my fear is that he is going to reoffend and that these behaviors and this conduct will continue. If the court places him on community control, it has the ability to kind of keep a tighter leash on him, monitor his behavior and require him to do a lot of treatment.
I tried that once, didn't I?
I know you. I know, Your Honor.
Not in the too distant past.
And I wholeheartedly appreciate that, Your Honor. But I do think he's different than he was at that point in time. He is accepting responsibility, acknowledging certainly the substance issues. That has been a big change. And contrary to what was stated in the cite eval, my takeaway and my experience with him has not been a lack of remorse. However, I will let my client address the court and I'll let Your Honor make its own assessment. But that has, my experience has not been a lack of remorse. That being said, I think that this court's in a difficult position to try to fashion a sentence that will protect the public and try to prevent these actions from repeating themselves. Thank you.
Thank you, Mr. Hopkins. What do you want to tell me before I impose sentence?
I'm truly sorry to both victims, parents. I feel remorseful. I regret each and every day the pain that I caused towards them. I truly just need help figuring myself out with these sex treatments and, just hoping I can go to a sex treatment. I just feel like prison will not help me. There's no excuse for my actions on what I did.
Prison generally helps nobody.
Yes.
Just so you know that.
And there's no excuse for my actions. What I did wrong was wrong, and I should knew better than what I did. And it won't happen again. I promise you, it won't happen again. If you give me a second chance. I feel like I've been praying each and every day, and been sending letters to you each and every day, trying to show you that I need help, and I'm begging for help. I pray that you can help me. And I just truly just sorry for the behavior that I have done, and any consequences or the actions the punishment that's going to be opposed. I accept it, and I'm truly sorry, and I regret each and every day. And I just pray that everyone in this courtroom can forgive me, and just hoping that I can just have a second chance and be able to just learn from my mistakes.
I mean, you say everyone in this courtroom, I mean, don't include me in that because I don't forgive. That's not my role, is to forgive.
I understand.
Anything else you want to say?
Just really sorry that I brought pain on both victims and their parents, and I can imagine how they're living right now. I'm just truly sorry, and just hopefully they can just understand that I'm not a monster, and that I'm a good person, and I'm truly just sorry, and I'm really remorseful for what I did, and I'm sorry for what I did. I just truly need help, and I'm begging you to help me, and I'm calling out for help. I need help. Thank you.
Mr. Randazzo, in the intervention case back in May 7th of 25, when I placed him on intervention, there was an order that he complete dual diagnosis program at Action Recovery and follow all recommendations. Do you have any information on that?
So we amended that a long time ago. Action was an online only.
All right.
We switched to Signature Health.
Okay.
And he has done a less than par performance of Signature Health with his IOP and dual. He would not get up in the morning, so he has been in IOP during the whole entire duration of the supervision because he never completed it due to attendance.
And that was a dual diagnosis, correct?
Correct.
For mental health
And drug and alcohol.
and drug and alcohol.
But his
And so,
attendance was poor.
do you know, and this probably isn't fair to you since you weren't, I don't know if you have the information on that, but what did they diagnose him with at Signature, do you know?
I have to dig through the file.
All right, take a look in the meantime and see if you can, Ms. Snavely, do you have some information on that?
Your Honor, I believe when the psych evaluation was completed, they did rely upon the collateral information from Signature Health.
Okay.
And did indicate, I think Mr. Hopkins indicated a diagnosis of depression, bipolar disorder, post-traumatic stress disorder, and anxiety. It does indicate that, I think, as a result of the counselor's own assessment and the collateral information, that he does obviously meet the criteria for cannabis use disorder, severe, alcohol use disorder, severe, and I don't know that it actually states. However, I do recall those specific diagnoses.
Okay. So what,
from Signature Health.
Mr. Hopkins, what information did you give to Signature Health when you were evaluated by them as to your predatory sexual proclivities? Did you tell them about the problems you have with your attraction to minors and things of that nature?
I did tell Bree Riley. That's what Signature Health. She's comes to the jail every.
So were you honest with them with regard to that?
Yes, sir.
Okay. And what did they recommend?
She was recommending me to go to NeoCap and go to a sex treatment facility. And
Okay. When was that?
this is before I got here, a week ago, last week.
Okay. I'm talking about when you went to Signature initially. When did you go to them for your dual diagnosis evaluation?
I
You
went
know?
to, February 26th. The day
February
of-
26th.
No. When did you first begin treatment with Signature Health?
It's roughly May of 2025.
Yeah.
May
Okay.
7th.
Okay.
All right. And do you know what they diagnosed him with?
I actually did find that it says a review of Mr. Hopkins' records
No,
from Signature Health.
that's from Lake Geauga, right? It's from the.
No, it says a review of the records from Signature Health reflects the most current diagnosis as generalized anxiety disorder, post-traumatic stress disorder, and bipolar 1 disorder.
Okay. So they didn't diagnose him with anything with regard to the sex situation.
No, Your Honor.
That tells me that you weren't honest with them, or they would have addressed that. Okay. So when you say that you need treatment and you're begging me for treatment, okay, you had that opportunity in May of 25 that you blew off.
I didn't get to tell them that until now.
Okay. All right. Now, you said you were sorry to the two to the two victims
Yes, sir.
in these cases, and that's what you've pled guilty to cases involving these two particular individuals.
Yes, sir.
How many other individuals did you contact to try to pursue your deviant behavior?
None.
None? How
I
many?
mean, I guess when I was reading my indictment, it says.
I'm not asking you about reading your indictment. Hold on. We can only talk one at a time here. You engaged in behavior with these two 15-year-olds.
Yes.
And you knew they were 15, right?
Yes, sir.
Okay. And you consciously engaged in sexual activity with these 15-year-olds. How many other 15-year-olds or girls in that age range did you attempt to contact to engage in this behavior?
Only 6.
6?
Yes.
Okay. How were you trying to contact them?
We're just seeing each other on the streets.
What about Instagram?
Um,
What about Messenger? What about social media contacts? Did you try to contact girls on social media in whatever one you used, whatever format you used?
mainly just Snapchat, but I would mainly just see them out in the streets.
Okay. So how many times do you think you used social media to try to link? Is that the word link? Is that the word you kept using with these girls, link?
Yes.
Okay. What does link mean?
Do you just want to hang out?
Hang out?
Hang out, catch a vibe, go out to
What's a
dinner.
catch a vibe mean?
Like go out to dinner.
Go out to dinner. What is that all link means?
I mean, yeah, that's in my perspective. Yeah.
I thought in reading some of this that meant to have sex with these girls. Isn't
No,
that
sir.
what that meant?
No, sir.
Okay. All right. So you think in total you pursued 6 other girls like this?
Just yeah.
6 between just people meeting out in the streets and on social media.
Yes.
Okay. Well, I don't believe you. I think there's a lot more than that. So how did you meet this person called Sophie?
Sophia.
Sophia, whatever. How did you meet this person?
I met her on. She came to me on Snapchat.
Okay, social media.
She knew me.
How is it that she came to you on Snapchat?
She came to me asking, "Hey, can you take me to places to give her a ride, like parties?"
So
for
she
gas
just
money.
she wandered on the Snapchat, is what you're telling me, and just contacted you to get rides from different places?
Yeah, it was like we never had any engagement of sex or any.
I didn't ask you that. So you're on Snapchat one day, and I don't know how that stupid thing works, okay?
Mm-hmm.
But you're on Snapchat one day, and Sophia or Sophie or whatever her name just gets a hold of you to ask you for rides.
I guess she knew me from a friend.
What friend?
I'm guessing people that's telling her about me.
Telling her about what?
I mean, I guess because I'm a rapper, so a lot of people know who I am.
Okay.
And I have a little bit of publicity. I have a lot of fame, a little bit, and she just knew of me. And I guess because I have marijuana, and she knew that I can get marijuana and alcohol for them. She hit me up.
When did you get a hold of her?
This is back in October 15th when they told me that they.
So that's when you first met up with Sophie or Sophia?
Yes, sir.
Okay.
And
Now, didn't I tell you as part of your intervention that you couldn't use drugs or alcohol?
No, you gave me a medical card.
Okay. How did you meet these 2 girls, the subject of these 2 cases?
One of them was Sophia friend, Alessandra Ambrose, and Armani was a person that I just met on the media, on the house.
How did you happen to meet her on media?
I guess we just came across. We were sending streaks to each other.
Sending
And
what?
Streaks.
What's a streak?
Like Snapchats, outside or
Why were you sending? Why were you sending each other streaks?
to get our ranking up, as in
To get what?
to get the rank up as a streak. It's
I don't know what that
it's hard to say because what Snapchat is.
Okay.
But we just end up starting to hang out. Wasn't nothing about until a month later, October. That's when all this happened.
In each of these cases, you knew that each girl was 15 years old, right?
Well, Armani, both of them lied about their age.
All right.
But so I didn't figure out until I got inside this jail facility.
You didn't find that out. So the second one didn't tell you at some point before you engaged in sex with her that she was 15?
No, she told me she was 17. and
Okay,
then-
well, you acknowledge yourself that she told you she was 15 before you did this stuff. And haven't you made comments all over the place that didn't matter how old they were to you? Age is just a number, it doesn't matter. Didn't you say that?
Yes, sir.
Okay. So don't tell me you thought they were 17, because it doesn't matter to you anyway.
I'm saying Armani told me she was 17.
Well, she told you she was 15 before you had sex with her. You acknowledge that. Those are your words, not mine. I'm not concluding anything. Those are your words. Okay? And now, one of these girls you told that you have young kids locked away in a house somewhere.
That's not true.
Well, why did you say it?
I was off of a lot of drugs, alcohol.
That's a goddamn strange thing to make up, isn't it?
Yes.
That you got little kids locked away.
It was just a joke just to see how she was going to react.
What reaction were you trying to get out of her?
It was just something. It was just a joke that I should have never had.
It's a joke. It's not a funny joke.
It's not.
Okay. A joke is something that makes people laugh. You were trying to scare her, weren't you? Why else would you say that?
Just to see how her reaction would be, sir.
And what was her reaction?
She started crying.
Okay. Is that the reaction you expected?
No, sir.
What reaction did you expect?
I just thought she was just like, I didn't think she was going to take it serious. Like how she took it serious.
Now, both of these girls have had some trouble in their lives, right?
Yes, sir.
Both of them were in juvenile detention center, right?
Yes, sir.
One of them had an ankle monitor on, right?
Yes, sir.
Okay. See, my read on you is you sought out young girls who were troubled that you could take advantage of. Am I correct?
No, sir.
I'm mistaken.
No, because I
So
don't-
tell me what it was then. You just sought out any young girls, not troubled?
No, sir. That's not how I am.
How are you?
I just thought they just had ankle monitors. I was just seeing, hey,
They're what?
I'm not a monster. That's what I'm.
I didn't say you were a monster. I'm asking
I'm
you
not saying
what girls you sought out.
I'm saying I seen them that they had ankle monitors and they was just
Ankle monitors.
They was going through a lot, so I was just trying to help, but I wasn't trying to like take advantage of or manipulate them or anything.
Well, the one girl you met through Sophia on October 15th, within a couple hours you're having sex with her in the front seat of the car, right?
Yes.
Okay. But you weren't trying to take advantage of this girl.
No, sir.
No.
She wanted to. Like
She wanted it.
She asked me. And when she cut off, I didn't even know she cut off her ankle monitor. She cut off her ankle monitor and told me she got raped by 2 guys. And that's when I went to go pick her up. That's when Sophia told me to go pick up my friend. Hey, can you go pick up my friend for me? And I'll give you gas money. I was down at my lowest. I didn't have no money at all.
And then when you were asked by, I think, Detective Fawcett or Detective Liam Bruno, I can't keep track anymore, if your seminal fluid would be in her vagina, you talked about how you had an old condom that was in a cup in your car, and maybe she inserted that into her vagina. Is that what you said?
Yes.
Well, why would you say that? Why wouldn't you just say, yeah, we had sex and she wanted it?
Because she told me she got raped by 2 guys.
Okay.
After she cut off her ankle monitor at Minter Mall. at Minter High School, 2 guys came and
All
picked
right,
her up.
see, I don't believe that either.
I swear I have that in my phone.
Good.
If you would have let me just get my phone and I could show you evidence in my phone that that's the truth. I promise you.
But regardless of that, you're not charged with rape. You're charged with having sex with this girl because she was 15 years old, right?
Yes.
Okay.
But she told me she was 17. I did not know that.
Okay. Well, that's on you.
And I understand that.
That's
and I
on
take
you.
all accountability for my actions. I understand that. But I have text messages and proof if you would have just let me get my own phone and I could show you that they told me and they lied about their age and everything.
Okay, so that semen got in her vagina by an old rubber of yours, is that right?
No.
No. It got in there because you had sex with her, right?
Yes.
And you wanted to get her pregnant, right?
No.
No? You didn't say that?
No.
You didn't say that to multiple girls?
I not do I recall.
Do you recall saying that to another one about your girlfriend on July 30th in the email from the jail?
How do I recall?
You come here and you tell me that you're sorry to these victims
I am.
and that you're taking responsibility for things. But, man, you shade everything you can to make you look better.
I don't.
You do.
I'm just trying to tell you
You
the
have.
truth on
You've
what
been doing
happened.
it for 20 minutes.
I'm just trying to tell you the truth. I don't want you to seem that I'm a monster and that these people did not lie about what they said. If I had my phone and showed you proof, this case would have been myself, though. If I
Well,
could show you.
the truth is that you know they're underage, that you look for girls that are underage, and you have sex with them. That's the truth, right?
No, sir.
It's not.
Literally, Armani told me that she was 17. She didn't tell me she was 15. And I understand that's still against the law, and I'm sorry, but I did not know they age.
But then again, I don't know that you spent any time thinking about how old
I
they were.
have.
Because you're the one that said 15 don't matter, age is just a number, right? That's your words.
I didn't say 15 was just the age. I just said if I would have known he was 15, I would have never had sex with him.
Well, you knew the one was 15, and you had sex with her anyway, because you acknowledged that.
I did not know she was 15. I only said that
Why?
said that because I said that because I didn't know because if they would have took it to trial, they was talking about they was gonna hit me with a rape case or whatever. So that's the only reason why I admitted to saying that.
That's got nothing to do with anything.
She told me that they both told me that it was 17.
Right.
I did not know they age.
Well, let's be clear about something here. I don't believe you.
I understand you don't believe me, but I promise you that I'm telling the truth. I did not know they age. But if you don't believe me, then I understand, and I'll take all punishment. There's actions that's going to happen. But I'm telling you the truth, and I promise you, I did not know that. I'm telling you, I need help. I'm begging for help.
Well, you know what? I gave you the opportunity for help on May 7th of 25, and you blew it off. As a matter of fact, while you were still on intervention reporting to Miss Randazzo, you were leaving there and running over to see these girls. So you didn't want help. If you wanted help, then you'd have gotten the help when you had the opportunity to get help. But you liked what you were doing, and you continued to do it. So don't tell me you want help, because you had that opportunity. What else you want to tell me?
I mean, you don't believe me, so I guess you just gonna do whatever you're gonna do. I'm sorry for my actions. Take all punishment for my actions. I'm sorry for all victims. I'm sorry for everyone in the staff. What's happening? But I promise you, like, if you send me to prison, it's not gonna help. It's not gonna help. I need help. I'm asking you for help. I'm calling out for help. I'm begging you for help.
May 7th of 25.
I had a medicinal medical card.
May 7th of 25. Dual diagnosis, mental health and drugs. You blew it off.
I was still trying to do the best thing I can do. I was still attending Signature Health. They came and picked me up at Signature Health on February 26th when I got incarcerated. I would like to go back to Signature Health. I would like to start over and have a second chance.
You don't seem to understand something. That sentencing is punishment and rehabilitation. You're kind of blowing past the punishment part of this thing. You can't do what you did.
And I understand that.
That's serious.
And I understand that. But I don't want you to think that I'm a monster and that I'm just telling full bit of a lie when I'm literally telling the truth. If I had my phone directly in my hand, I could show you proof. But since the detectives and prosecutors, they have my phone, so you gonna go based off on what they say.
No, I'm going largely based on what you said, both in recordings, both in statements. I'm going off of what you said. I'm taking into account what others say and evaluating what they say. That's what I'm doing. And the long and short of it is, you don't care what their age is. You know what their age is.
I do care.
And you're doing it anyway.
It's not true.
Okay. Ms. Gold?
Thank you, Your Honor. It is the state's position that the defendant is not amenable to community control sanctions and that prison is the only appropriate sentence in this case. The defendant is a predator and the defendant preys on vulnerable minor females. Your Honor said it perfectly when you said that the defendant sought out young girls who were troubled who he could take advantage of. The first victim, minor victim AA, the defendant met and had sex with in his car just hours after meeting her and then again the following day, knowing that she was too young for this conduct. The second victim, minor victim RP, the defendant met on Snapchat, the forum where he would use to recruit young girls, where he would message the word link to multiple girls in order to arrange to have sex with them. The The defendant knew that he was 10 years older than minor victim RP, and regardless of this, the defendant carried on a relationship with her for approximately 6 months. Their sexual conduct took place in various cities throughout Lake County during that time. And not only did the defendant have sexual encounters with her for 6 months, but during this time, as well as the time frame that the defendant engaged in conduct with minor victim AA, the defendant was on an intervention plan with this court. The defendant would go to Paynesville to meet with his probation officer, Ms. Randazzo, and then he would go to the apartment where minor victim RP lived with her family in Paynesville, knowing that she was exiting the apartment so that her family would not see her leave, and then she would get into his car and they would drive to a secondary location and engage in sexual conduct in the defendant's car. Now, the defendant has said today that he is remorseful, but this is not what his actions have shown over the past month. In reviewing the pre-sentence report, this court has had the opportunity to see how the defendant has been behaving in the jail, and this behavior includes misconduct in the jail, as well as advances that the defendant has made, inappropriate advances towards a correction officer. Not only that, but this court has had the opportunity to view jail messages the defendant has sent since being in the jail, awaiting sentencing, talking about having a 17-year-old girlfriend and making statements about not caring about age. The defendant is harm to society and has demonstrated that he is a predator. The defendant talked today about not getting help for his mental health treatments. This court, as noted, did previously offer the defendant opportunity, in fact, court ordered the defendant to get such treatment, and this is treatment that the defendant in the first place did not need court intervention to obtain. The defendant could have been obtaining treatment throughout this time. Instead of this, the defendant was engaging in a course of criminal conduct, being multiple felonies with minor victims, and prison is the only sentence necessary and appropriate to punish this conduct. Thank you.
All right, I've reviewed the pre-sentence report, the evaluation, psychological evaluation. There were no victim impact statements. And I have reviewed the docket in each of the 3 cases, also including the 1155 where there was the intervention which was revoked and you've pled guilty to. I have considered all the provisions in 29, 29, 11, 12, 13, and 14. I have concluded in reviewing the reports and the record and listening to you that you are clearly a sexual predator.
I'm not, I promise.
You are. You are. You are. So you are not amenable to community control based on the nature of these offenses and the fact that you were on intervention when you committed these offenses. Intervention to give you the opportunity to get the help that you tell me you need, and you completely blew it off. So you are not amenable to community control. On the 1155 case, 24-1155, what was the intervention case, on each of those 6 counts, you're sentenced to 12 months in prison. On each count, they'll be concurrent to one another, 193 days credit. On 26-291, on count 1, I'll impose a sentence of 54 months. Count 2, 18 months. Count 3, 54 months. Those will be consecutive to one another for a total of 126 months with credit for 182 days. 1155 will be concurrent to 291. On the 869 case, on count 1, 54 months. Count 2, 54 months. Count 3, 54 months. Count 4, 18 months. They'll be consecutive to one another for a total of 180 months with 56 days of credit. And 291 and 869 will be consecutive to one another. Consecutive service is necessary to protect the public from future crime by you and for the appropriate punishment, and consecutive sentences are not disproportionate to the seriousness of your conduct and your obvious danger that you pose to the public. The offenses in 269 or 291 and 869 were committed while you were under the intervention sanction, and your history of conduct demonstrates that consecutive sentences are necessary to protect the public. And at least 2 of the offenses were committed as part of a course of conduct, and the harm caused by those 2 offenses was so great that no single sentence adequately reflects the seriousness of your conduct. When you get out, you're going to be on post-release control for 5 years under the parole authority with conditions. If you violate, parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months for the time left under post-release control. Costs are assessed on each case. Anything else, Ms. Gold?
Your Honor, in case 26 CR 291, for counts 1 and 3, the defendant pled guilty to a lesser included offense of the F3 being an F4, where the maximum sentence was 18 months.
Well, I gave him, on count 3, I gave him 18 months. I'm sorry. Okay, so it was 54, so 18. Okay, I see what you're saying. So count 3 and 291 was an F4.
As well as count 1, Your Honor.
So 18 on count 1, 18 on count 2, 18 on count 3 for 54 months. Anything else?
No, Your Honor, thank you.